And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. As always, it's your opportunity to get free legal advice between now and 9:30. All we'd like you to do is get on that telephone as soon as you possibly can. 55208888 is our number. That's 55208888. Don't forget to put 07 in front of the number if you live south of the Tweed River. And you can always send us an email at talkback@4crb.com. which we would be able to deal with in next week's program. 55208888. The lines are presently open, and who knows, you could be our very first caller for the program today. While we're waiting for some calls to come in, thank you to all the people who called in last week to make for a very interesting program. Since we've come back live in the studios, we've certainly had a couple of great programs with wall-to-wall calls, which is what we want. And one call that I'd just like to make a little comment on this morning was our very first caller from last week, Robbie. You may recall that Robbie rang saying she'd purchased a sewing pattern for a toy, and she'd made one. I think from memory it was for one of her family members, but she was looking at perhaps making more and selling them online, and the issue was whether she would be breaching the copyright in the pattern. And as I said at the time, it would depend on the terms of the contract under which she purchased that pattern and from the owner of it. But I've been thinking about it during the week, and there are a few other issues, Robbie, if you're listening, that I think are relevant. The first one, of course, is whether the person you actually purchased the patent off has the copyright in that pattern. So that would be the very first issue. And then the other one, of course, would be whether there is anything on the pattern which suggests that there is copyright in the pattern to the owner, because that would, of course, be a very clear sign that there was an issue. But I think from memory, last week, Robbie said that there was nothing on the pattern at all. It was simply a pattern that came through the mail and there was nothing on it. So normal principles do apply, as I indicated to Robbie. The person who creates the design has the copyright in that design, and a pattern for something to sew is no different, for example, to house plans, where if you were to have an architect make some house plans for you and you purchase those house plans off the architect, then it's clearly implied that those plans only apply to the one-off use for the home that you're intending to build, because they normally refer to the address on which the house is going to be built, and they certainly don't give you the right to use those plans and then just reproduce that house on a number of other properties. So I hope that's a little bit of assistance to you, Robbie, and might clarify the position a little further for you. But we're still waiting for some calls to come in. The number is 55208888. That number again, 55208888. We'll be back after this word from our sponsor.
3 meals per day in dining room, weekly clean and heavy laundry service, courtesy shopping daily bus, doctor's surgery and 24-hour emergency care on site. All this is included with Earl Haven Lawrence Drive assisted living fully serviced apartments. Prices start at $110,000.
To inspect our service departments, please call me, Shelley, for an appointment on 5578 3433.
Our sponsor, Earl Haven Lawrence Drive, Nerang.
This is The Law and You on 4CRB. Our telephone number 55208888. That number again, 55208888. The lines are presently free, so if you have a question or a query, you can give us a call right now and you'll get straight through on that number, 55208888. There were a couple of things that I had been trying for the last couple of weeks to just raise in the program, but fortunately, the number of calls we've had over the last couple of weeks meant that I wasn't able to do so. But one of those, which is very topical at the moment, is your ability to terminate a contract due to the current COVID-19 pandemic. There are many people who think that because of the COVID-19 pandemic that it's carte blanche for cancelling contracts, but that is certainly not the case, and there are only limited circumstances in which you can renegotiate contracts that have been impacted by the coronavirus. One obviously would be or that the government has actually enacted laws about, is commercial leasing and residential tenancy agreements. And to a certain extent, the law may also allow you to terminate a travel contract, for example, or to get a refund on a travel contract where you've not been able to undertake the travel because of the COVID-19 virus. So they're just a couple of examples. But generally, if you're buying a car or buying a block of land, those sorts of things, those contracts would not be able to be terminated or renegotiated simply because of COVID. But enough of that. We've had a flurry of calls come in, and we'll say a very good morning to our first caller, Peter. Good morning, Peter. How are you today? Peter, are you there? Hello, Peter. No, we seem to have mislaid Peter at the moment, so we'll go to Bill. Good morning, Bill. How are you? Hello, Bill. Are you there? Oh, we seem to be having a little bit of trouble with our...
It's not me, is it?
Bill, are you there?
No.
Bill, are you there? Hello?
Yeah.
Hello, Bill?
Hello.
Yes. Sorry, Bill, I'm just finding it a little bit hard to hear you at the moment.
I'm Peter.
Oh, you're Peter. We've got Peter. Okay. I don't know what's happened to Bill then. Sorry, we've just got a bit of trouble on the switchboard. How are you, Peter?
She said I was number one, so I got a bit confused with Bill.
No, you certainly were number one, and I attempted to answer your call, but for some reason you weren't there. So there was just a bit of trouble with either with our switchboard or our panel in here. But anyway, we've got you now, Peter. So how can we help you today?
Just a couple of questions, if I may.
Sure.
If you want to leave a family member out of your will, do you put that in your will and the reasons? Or, as I heard on Nightlife a couple of weeks ago, the solicitor from Sydney suggested that you don't put it in your will and you make a statutory declaration with it.
Bill, Peter, it's interesting that you should raise this because we had this very question come up in the program last week. As I indicated last week, my recommendation would be that you do not put it in your will because the will is a public document, and particularly if you're talking about your spouse or one of your children or someone who's legally dependent upon you or someone who was in a previous will that you had, they are entitled to see a copy of your will. And so therefore, it's better that the will is basically a public document. So it's better that you don't put in your will, I haven't included my cousin Frida because she's a scumbag or something like that. It's far better that you put in a statutory declaration which is completely separate to your will and which is held by your executor so that in the event that the person that you've excluded from your will attempts to challenge it, for example, if it was a cousin or just a friend trying to challenge it, if they were in a previous will, to say, well, you didn't have capacity at the time you made the new will, or alternatively, if it's someone who comes within the class of persons who can claim provision out of your estate, for example, a spouse or a child or someone financially dependent, then you are better to have it in a stat dec. So the person that you're looking to exclude, do they come within the FPA?
No, it's my brother.
Okay, well, your brother doesn't have any entitlement under your will. So as long as you are legally, as long as you have legal capacity at the time you make a new will and you leave him out, you wouldn't even need to make a stat dec to say that you've left him out. But if you've got any worries that he might try and challenge your will, saying that you didn't have capacity at the time you did it, you made the new will, leaving him out, then you might be advised to get a doctor's certificate to say that you were mentally competent at the time that you made the will.
Okay, John, thank you. Can I ask another one?
Sure.
The second one is, if I bought a property, which I did, say, 15 years ago, and it's in my name, and I rented it for 3 years, therefore there's capital gains tax. When I pass away and I leave it to my wife, does she pay capital gains tax?
No. So if you leave the property to her under your will, she inherits your capital gains tax base. So you say you purchased it 15 years ago and you rented it out for 3. Does that mean that you lived in it for the other 12?
Yes.
Yeah. Okay. So when it comes to calculating the capital gains tax, there are a number of ways that they look at calculating. One of it is that it's 3/15 of the gain. But if it's now your principal place of residence, you can certainly leave that to your spouse. The other thing you could do, Peter, which might make it even easier on the administration of your estate, and this depends on your circumstances with your spouse, is that you can, at this time, put the property... You live in Queensland, do you?
Yes, I do.
Okay, so you could put the property into the joint names of yourself and your wife as joint tenants, which means that on your passing, the property would automatically devolve to her.
Right.
All right, then.
Okay, John.
Okay, all the very best.
Very much.
Time on 4CRB, just coming up to 17 minutes past 9. Do we have Bill, or is Bill gone? No, we don't, but we'll go to Sue. Good morning, Sue. How are you?
Oh, good morning, John.
Is that Bill?
Yes, still speaking.
We are just having some major confusion with our board here at the moment, Bill, but I'm very pleased to speak to you. How are you today?
Very well, thank you.
How can I help you?
It's a procedural question. When a will is changed, what should happen to the previous will? Is it destroyed, or should the solicitor's firm retain it for a number of years?
Well, my view is that the will should be retained. Sometimes it's penciled on it that it's been revoked, but the will, in my view, should be retained, because if ever there's a question about the later will, then the earlier will may provide a guide to what has occurred. So, for example, if you make a will and it leaves someone out of the will, and they say, "Oh, look, the only reason they left me out of this will is because someone got in their ear and turned them against me, and the will was made under duress. It wasn't really their wishes at all." But if you have an earlier will that's still held even though it's revoked, and that will says didn't include that person as well, then of course it pretty well destroys their argument to say, there's been undue influence in doing that. And I had that very situation many years ago with a will where some relatives in New Zealand were trying to challenge a client's will on the grounds of incapacity. And saying that, there was an earlier will that left them in it, etc. Well, we were able to show that there'd actually been 5 wills since the one that the relatives were talking about that had not included them. And so it pretty much destroyed their argument that the testator was not of sound mind and or alternatively was subject to undue influence. So, yes, the retention of the old wills is advisable.
And should that be retained at the solicitor's office or with the?
It should be retained with. It should be retained with the latest will, and my recommendation is that you should store those with your lawyer in document storage.
Right.
All right then.
And if there's a change in ownership of that legal firm, those records should still be passed on.
Yes, they should be. Though, if there's a change of ownership, they're normally passed on to the new firm, and that firm will then write to all of the people whose documents are held in storage. In the rare circumstances where a law firm may go out of business, then the Queensland Law Society will quickly send in receivers to that practice and take over all of the records, and the Law Society will write out to all of the people telling them. So, but if you're if you have your will stored with a fairly large firm that's been around for a long time, you can be pretty safe in the fact that it will be secure.
Right. Thanks very much, John. Much
Okay.
appreciated.
And the other thing to bear in mind there, of course, is that the banks are getting out of the document storage business, so it's becoming increasingly difficult to have a security deposit box with a bank, which used to be very common years ago, but as I say, it's certainly far less common now. Now, the $64 question is the next caller going to be Sue or is it going to be Robert? So let's see. Hello, Robert, is that you?
Yes, that's me.
Oh, we've got Robert. So sorry, Sue, we don't know what happened to you, but if you're listening, you can give us a call back. Hi, Robert. How can we help you today?
Yeah, John, I was just wondering, in these days where we have some arrangements made, trying to think of the word, over the internet, like by email, what's happened is I've engaged the guy to replace some exterior steps at my place.
Yep.
He's come and knocked them down, and he hasn't been back for about a month.
Mm-hmm.
So if I ended up getting somebody else in to do it, could he ever come back on me at all?
For what?
For payment for work, not for the whole lot or whatever?
Well, how much?
Only for what he's done.
How much work has he done?
He's knocked down the steps, and the landing is up the top. He's replaced some studs there and that type of thing.
Mm.
He's also got all the new threads and all this type of stuff that he's needed to build the new steps with. That is not here on the property. Yeah, he's still got them.
Oh,
I
I
haven't
see.
paid him anything yet at all. You know, he's not even had. He was after a deposit, but I haven't paid him for that either. You know, so he's got no money from me. So he's actually got no money from the work he's done at the moment. But if I ended up getting somebody else who finished it off,
So
would he have to come back?
has he stopped doing the work because you wouldn't pay the deposit, or has he simply stopped doing the work?
I think he's been doing work somewhere else as well. You know, I think that's the problem. He's been busy with other jobs.
Well, I think what you should do, Robert, to be honest, before you engage someone else to complete the steps, have you tried phoning him?
Oh yes, I'm going to phone him more or less after I get off the phone with
Yes.
you. Okay.
So I think what I'd do is phone him up and just say, look, however long it's been since he originally came and knocked the steps down, and that that delay is unacceptable. And you're giving him however many days to recommence the work. What do you estimate the value of the work that's on site at the moment?
Probably about $1,500 worth, Dave.
All right, and what's the total value of the work to be done?
It's about, probably about 2,500 or something. I think he originally quoted me.
So he's more than halfway there then, by the sound of it, if he's done $1,500 and it's 2,500. So the only thing I could suggest you do is to say to him, look, I'm giving you 7 days to get on site and finish the job, and I want it finished within another 7 days. I'm prepared to pay you for the value of the work you've done to date on the day you turn up on site to recommence the work, but I would be getting something recorded in writing to say that he will finish the work in a good and tradesman-like manner within whatever number of days you're prepared to agree to, and you could pay him for the work that's been done to date, which would be probably more than the deposit anyway. And then the other alternative, or the other thing you may wish to do, would be to get a quote off someone else to finish the work, so that you know what you're going to be out of pocket to finish it, and to hold that amount back from him, but to get a clear understanding that if he doesn't finish within a reasonable time, then you're going to terminate the contract and have it finished by someone else.
Yep. And when you talk about getting it in writing, does an email count that way?
Oh yes, an email would count. So, I would probably be inclined to write something up to have him sign when he comes, and you give him whatever payment you're going to agree to give him. So you could just set it out, contract for replacement of steps, whatever the specifications are, agreed price, work to date, X, balance to finish, agreed completion date, whatever. And importantly, just put on the contract, time is of the essence of this contract.
Right, yeah.
Okay, so time is of the essence of this contract, because if he then fails to complete the work in the time nominated, then you would be entitled to terminate the contract and get someone else to finish it.
Okay.
All right then.
Thanks, John.
Okay, Robert, all the very best. 26 minutes past 9. This will be our last caller for this morning as we say hello to Ernie. G'day, Ernie. How are you? Ernie, are you there? He's driven off in the fastest milk cart in the West. Ernie.
Good morning, John.
Yeah, g'day, Ernie. How are you?
Yeah, going very well, thank you.
Good on you. How can we help?
I heard you just on the radio a little while ago about terminating a contract in relation to a holiday.
Yes.
My wife and I had booked a holiday to Fiji back in February this is before COVID lockdown, etc.
Yep.
For April.
Right.
As time came around, that time lapsed and we couldn't go.
Yep.
Because of it. And they said, okay, we'll rebook you for October this year.
Mm-hmm.
And while we've said, okay, now time's marching on, and we're thinking that maybe we wouldn't be allowed to go anyway, because Mr. Morrison has said that you wouldn't be able to fly out of the country anyway, for a starter.
Yeah, that's right.
And this has probably been asked before, but I haven't heard it. But what's our position in terms of getting our refund, because it was all paid up front?
Right, okay. Well, it's unfortunately one of those classic answers, Ernie, and that is that it depends. So I would certainly be asking for a refund because of the uncertainty, and I would be, particularly with some of the larger travel companies, they are agreeing to refunds. The important thing to me is whether the travel company that you've booked through has had to pay the resort where you're going to stay. And it's amazing when you make inquiry, you find that they haven't paid for the holiday at all. So they're just holding the money, and they're holding your money. And really, if there is some uncertainty that you're going to be able to take the holiday at any time or within the foreseeable future, then I do not think it is unreasonable that you should ask for and obtain a refund. And there have been a number of people who have taken that matter up with the ACCC for assistance. And the other one, of course, is Consumer Affairs. So you can also take it up with Consumer Affairs. Do you live in Queensland or New South Wales?
Queensland.
Okay, so I would suggest that you could get in touch with Consumer Affairs. Have you got a pen handy?
Yes.
Okay, so their number is 137468. So I would suggest that you give them a call and just explain the circumstances to them. They may refer you to the ACCC, but without naming the company, which we don't particularly want to do.
No,
but if you're dealing with a fairly large and reputable tour company, then there shouldn't be too much difficulty if you jump up and down hard enough in convincing them that you do want your money back and that they should refund the money.
They are reputable, and we have booked through them before over the years.
Yes.
And they also made a suggestion that because the flight to Fiji was via Virgin Airlines. They're saying that Virgin are not refunding the money, so you'll do your dough on that one. But I was under the understanding that my contract was between the
Yes.
travel agent and ourselves. I had nothing to do with.
No,
who
that's
they booked it
exactly
through.
right. I don't think that matters at all. So
Okay.
I would be going after the travel company. I would be leaving the second part. Who they booked the flights with is entirely up to them. I mean, prior to COVID, there were a number of carriers travelling into New Zealand, into Fiji. You could go with Fiji Air, you could go with Qantas, or you could go, Jetstar, I think, and or Virgin.
Yep.
So, unless you specified Virgin as part of the booking, if they just simply gave you Virgin, well, that's up to them. All right, then.
Good, John. Thanks very much for
all
your
the
help.
very best with that, Ernie. And the time is just coming up to 31 minutes past 9. Thank you to all those people who've called in this morning to make for such an interesting program. Sorry about the issues we had with our switch and calls, but hopefully we'll be able to get that sorted out for next week. And a special apology to Sue, who didn't seem to be able to get through. But Sue, if you're listening, please give us a call for next week, or alternatively send us an email. I'm John Fradgley from the Bell Legal Group. Until next week, it's goodbye and God bless.